polluted by impurities. I want to persuade you that my 2 decades of practice at the bar have taught me that judges are just as polluted as the rest of us. Judges are just as political as the rest of us. And I think what will inform many of you is that I've had the rare privilege in life. Life has been gracious to me, that among the many clients I've dealt with in my life, by latest review, I have handled cases of at least 33 judges as my clients, by the latest statistic in my office. And therefore, I have sat with them now as clients, as litigants, and listened to them. I have come to the inevitable conclusion that the people I'm listening to are not angels. They are practical human beings with flesh and blood flowing through their veins. And therefore, again, the obsession that perhaps common law trained lawyers have, that disputes must be taken to court, because that is where we are going to have an objective interpretation of law, is exaggerated. The best we get from courts is legitimate interpretations of law. That the courts have an aura of legitimacy, that as a such we have agreed that is okay, because we are all political beings, let us have one among us who, when he speaks, we then can go away saying, it's okay, I may not agree, but he's a judge who has spoken. So the thing that takes us to court is not necessarily objectivity beyond what we know in the rest of society. It is objectivity that enjoys legitimacy. Objectivity that has an imprimatur of legitimacy. Which then begs the question, being an emanation of society like the rest of us, do judges do politics? Do judges engage in politics? Obviously, if a judge was sitting in this audience, he or she would be extremely disappointed if they had me reach the conclusion that I'm about to reach, that yes, judges do politics. Because judges gain their legitimacy from the fiction that they are above the fray of politics, that they are beyond the heat and dust of politics, that judges, core judges, are objective arbiters of disputes and objective interpreters of the law established. In fact, if you walk through many of our courtrooms, you visit the court, even the way the place where the judge sits is designed architecturally is to lift him up above the rest of us, to symbolically create an impression that as the rest of us are fighting down here, the dust from that fight will not cloud the judge's eye. He's beyond these fights. I have made an earlier argument that judges are an emanation of society. I have also made another earlier argument that judges use their knowledge of law and their knowledge of society to sustain their legitimacy. And yet I have made a major premised argument that knowledge itself is not value neutral. Knowledge itself is value laden, and that the baggage of values that we carry with us like a hump on a camel's back is synonymous to our unique experiences. What were our early childhood exposures? What were our upbringing exposures? And what residue of impurities have those exposures left in us? Those things keep weighing heavily on us as we get along. Let me give you a few cases, a few examples of cases that have come before our courts, which will then show you that judges are just as political as society itself. If you look at the case of the NGO's board versus Eric Gitari, which is a simple case on the question whether the NGO's board can decline to register an ungovernmental organization whose mission is to foster the mainstreaming of what is now being called LGBTQ rights. And you look at the jurisprudence of the Court of Appeal and you ask the question, Look at the identities of the judges who take the view that the NGO's board was wrong, and you will discover that historically they have a background in social rights activism. Are we presuming that sitting on this bench, there are such objective interpreters of our NGO's coordination law as it was then, on the one hand, the penal code on the other hand, and the constitution on the other? Or are they carrying with them the baggage of the activism that has informed their earlier life and which has refused to leave them? When you look at the dissenting judgment of Justice Mohammed Ibrahim, you then ask the question, we all know the position of Islam on this LGBT question. Is he sitting as an objective judge on this question divorced from any extraneous consideration? Or is he carrying the baggage of his Islamic teachings, Islamic learnings, Islamic faith as he sits on that bench? That is how I reflect on this question of the interplay between law and politics. To the extent that it is impossible for me, sitting as an observer with my own impurities, to see that these judges are removed from that background of theirs as they make these decisions, I reach the inevitable conclusion that judges are invariably doing politics, particularly when they engage in politically sensitive cases. That judges wittingly or unwittingly tend to look over their shoulders to ask, and how is our decision likely to be received by the general public, as they make their decision one way or the other. Allow me to make just one more justification for this argument I have made before I move to the next limb of my argument. Judges claim that when they make their decisions, they take into account something called the public interest. And that this phenomenon called the public interest is not something over which they conduct a miniature referendum very fast to ascertain. They say sitting in the courtrooms where they sit, exercising their learning and their experience as men and women of the law, they are able to look at the public and ascertain the interest of that public. I have made out a case that just as politicians clothe their individual political interests and claim they are speaking for the mwananchi, judges oftentimes, in taking into account the so-called public interest, it is public interest in their perception as members of the public in their own right. Because let's not forget that a judge is not removed from society. I've argued elsewhere that no appointing authority goes to the skies and comes back riding on a mosquito with judges. Appointing authorities look among us and pick some men and women whom they think are judicious enough from this society. Sometimes the appointing authorities call upon to remove some of them from the bench, having tested them and found that they were wrong in assessing them to be judicious. Two African scholars have reflected on this question of whether judges do politics. I will reflect on the writings of Chief Justice Emeritus Professor Willie Mutunga and a professor at Makerere University, Professor Oloka Onyango. I was privileged to have been one of the respondents to Professor Oloka Onyango's book on whether judges do politics, or Judges and Politics. And I have been privileged to have worked with Professor Willie Mutunga, because we both teach at the Kabarak University School of Law, and therefore I've had a chance to test his thinking on this subject. Both CJ Emeritus Willie Mutunga and Professor Oloka Onyango have agreed that judges do politics. And they have reflected on a number of case studies that give them this conclusion. One of them is the prescriptions in Articles 20 and 24 of the Constitution on our Bill of Rights chapter of the Constitution. Our Bill of Rights chapter of the Constitution tells the judges mandates the judges that as they enforce rights, they must develop the law. They must develop the law. And I had a chance to litigate a matter involving that provision of the Constitution, and one of the questions I reflect on before Justice Mumbi Ngugi was, using what tools will a judge develop the law? Can a judge rewrite the law? If a judge can rewrite the law, then how does the rewritten text find its way in the statute book? And I did some comparative study from South Africa, from Canada, and from Hong Kong to persuade the judge, and the judges from the High Court, the Court of Appeal, and the Supreme Court agreed that there is a tool in interpretation of the Constitution that is called reading in. That a judge sitting as an enforcer of rights can read into a statute some words. And the Office of the Attorney General was at pains to understand what I was saying, because they kept saying, I am asking the judges to amend the statute. I said, no, I'm saying the statute will remain as it is. But as you read that statute, you must see some words there that are not there. That's what I call reading in. You must read into this statute some words in order to make this statute consistent with, then we are looking at Article 27 of the Constitution. And I kept saying that the dominant tool of testing constitutionality of statutes is by striking down statutes, where we find that the statutes are violative of the Constitution. But I kept asking the judges, what do we do with cases where we are saying the statute was on the path of complying with the Constitution, but it stopped short of? So we are not saying it is inconsistent with. It was consistent with, but it stopped short of the full expectation of the Constitution. I told them the remedy in those circumstances is to read in words for the statute to complete that journey it had begun of complying with the Constitution. One may call it the craft of an advocate. Definitely that person will be right. I can assure you, as advocates, doing our duty of representing our clients' interests, we engage in significant gymnastics to try and read, reread, overread the law to ensure that we achieve the ends that we want to achieve. Sometimes judges agree with us. Whether they agree with us to the ends of justice or whether they agree with us to the greater harm of society, I trust eventually society will judge us when it is placing our contributions on the scales of assessment. Professor Oloko Nyango, on the other hand, has reflected on the questions on whether judges do politics by asking the question, how can judges enforce socio-economic rights without doing politics? Socio-economic rights, by their nature, are resource sensitive. And there is something that we call the lock-on effect of resources. This is how it works. A citizen can go to a court of law and tell the court of law to make a finding that the failure of the Kisii County government to supply adequate water to Kisii University is a violation of Article 43 rights. That's a legitimate argument, particularly if you come across here and you discover that you don't have enough water to flush toilets. That may present a dignity question, isn't it? In many of our public universities and private universities, there is the toilet bowl and the cistern, but there is a bucket in the common area, so that the designer of the toilet knew that the water was supposed to be in the cistern, but invariably the cistern has no water. So to ameliorate the situation, there is a bucket and something to fetch water with. And the whole exercise is undignifying to the user of a toilet. So if you present that question to court, the Kisii County government may come and say, it's okay, you know, we have no problem giving water to Kisii University in adequate quantities, but our capacity to give water to Kisii University will impair our capacity to supply water to another slum nearby. Because the resources are the same. We would have to divert the resources of that slum so as supply water to this university. Or our capacity to supply water to Kisii University will impair our capacity to sustain the school feeding program of kindergarten children in our kindergartens in Kisii County. That's how resources work. But the Constitution empowers courts to enforce socioeconomic rights. It follows, therefore, that courts will engage in the business of allocation and reallocation of resources. Ordinarily, those were questions not in the domain of lawyers from whom judges are derived. And I don't know about your experience. My experience with the lawyers is that there are men and women who studied law because mathematics was not their forte. They were looking for a course that didn't demand a lot of mathematics. Now, they sit as judges, and they must engage in this business of allocation and reallocation of resources, business that we had hitherto left to mathematicians and economists to engage with, and to an extent, politicians as people's representatives who will engage in a political bargain to be able to give and take and see what to allocate. Professor Oloko Nyango has reasoned that to the extent that we have seen health rights issues, we have seen food rights issues, we have seen water rights issues finding their way to the courts, and courts being called upon to pronounce themselves on that question, judges cannot possibly enforce those provisions of the Constitution without making a political preference of their own over the political preference that the existing executive had made, whether it be the governor and his government or the president and his government. To that extent, therefore, judges do politics. What do we do as lawyers, therefore, on this understanding that there is a close nexus between law and politics? My first challenge goes to university law schools. There were days when we taught law in university law schools as if law was an end in itself, as if law was a God-given objective phenomena for resolution of societal conflict, as if law was itself value neutral. A time has come when law schools like Kisii University must relook their curricula to ask, to what extent are we engaged in an interdisciplinary and multidisciplinary study of law? To what extent is the curriculum of a law school like Kisii University engaged with subjects such as law and economics, law and politics, law and society, so that the future judges that we are generating from Kisii University are men and women who are adequately experienced, whose knowledge is knowledge that comprises of experience on law and the economy, law and politics, law and society itself, as opposed to just law as rules, as an end in themselves. That is critical. The other broader question that must bother us is this. In its origins, law was never meant to be a first degree. If you look at the origins of legal philosophy in the olden Roman times, where what you now call jurisprudence was called jurisprudentia, and what you now call jurists were called jurisconsults, law was studied by men largely, and women to a lesser extent, who had experience in other philosophies and sciences. So that one had to go to an institution of higher learning and pursue a program in mathematics, in philosophy, in literature, in economics. Once you graduate in each of those disciplines, you now become eligible to study law. The understanding at that time was that a study in history exposes you to an experience of humanity. An study of mathematics exposes you to an experience of logic. A study of literature exposes you to an experience of society. A study of history exposes you to an experience of society. That once you already have that experience, and you now sit in a university law class and you are studying law as rules, you are better placed to look at the rules you are studying against the background of the knowledge you have acquired in your earlier programs, and you are therefore bound to graduate as a lawyer who can delicately balance law and politics, law and society, law and philosophy, among other phenomena, in a neater manner than we do as lawyers who studied law as rules, as ends in themselves. So that's another recommendation that I'll make to you. I was reflecting on the teachings of law in the Philippines. There's a famous, those of you who study environmental law have studied a famous case from the Philippines called Oposa versus Factoran. And if you study the philosophy that the judges espoused in Oposa versus Factoran, in summary, was a philosophy of intergenerational justice and intergenerational equity, where some young children filed a case in court through their parents. So the parents didn't file the case in their own right. The parents filed the case as representatives of their young children. These young children were seeking to assert their own rights and the rights of children unborn to a clean and healthy environment in the future. And how they were doing this was by challenging a decision of the minister in charge of forests to give timber lumbering licenses, as we do in this country oftentimes. And the argument was simple, that if you go to these deep indigenous forests, like the Congo Basin, these forests have been there since the beginning of things. And existing generations have benefited from the ecological benefits of these forests up to now. Since they are about to die, they are giving licenses to people to cut them down and sell timber. And the persons most affected are generations unborn. And therefore, the court has a duty to intervene and affirm the rights of generations unborn. That was a very unique case at that point in time, because the way we know this thing called standing, locus standi, those of us who do litigation, perceive that locus standi is a right of actual legal persons. When you talk about generations unborn, controversial philosophical questions arise. Who are those? Who knows them? Where do they get standing from? But the courts asserted that principle of intergenerational equity and intergenerational justice and affirmed the rights of generations unborn to a clean and healthy environment, and quashed the decision of Factoran Jr., the then minister, who had given those licenses. I was reflecting on that case and asking, how did these judges engage with the politics of that case? Now, make no mistake, Oposa, whose son is called Oposa Jr., so Oposa himself was actually a lawyer by training, and he knew he could file this case in his own name. But you know, when you file cases in court, and you do that all the time, particularly public interest cases, you must be strategic. That's why we sometimes call public interest litigation strategic impact litigation. You must be strategic, and you must ask. Judges may determine this matter using the law. But what if I emotionalize this case? Now you are politicizing the case. I emotionalize this case by filing it in the name of a 3-year-old, so that the person whose case the judge is dismissing is a 3-year-old. It is much easier for a judge to dismiss a case in Ongoya's name than for a judge to dismiss an environmental claim by a 3-year-old child. So he opted strategically to file this case in the name of the 3-year-old. I then followed to ask, how have Philippines law schools, particularly the National University of the Philippines at Manila, done to create lawyers who are this sensitive to these political strategies. I learned that university has an interesting thing which you may take as a law school and see whether you can pioneer in that area. When you join the National University of the Philippines in Manila, you don't start by getting lectures in law. You don't start by learning definitions of the constitution or constitutional law or definitions of contract or tort. Name them. When you join the National University of Manila, the first 2 weeks, you go and live in a nearby slum by the slum dwellers. The university gives them something small to facilitate your upkeep there. So you live with them. You go to the markets with them. You go to the river to fetch water with them. You take water. You take showers in their shanty bathrooms with them. For 2 weeks. When your parents drop you at the university, they look at the university hostels and think that's where you're going to live. But the university has other news for you. That evening, you are spiraled into the nearby slum to live with the families there. You eat their food. You go to the market with them. You go to the river with them. 2 weeks later, you come back to the university a human being. You now begin understanding that the law you are studying here is law for justice, not law as rules, as ends in themselves. And because of that, the University of the Philippines in Manila has generated human-centered lawyers, lawyers with a heart for humanity, lawyers who understand that the law that they study in the university is as useless as it comes unless it can serve that slum dweller in whose shanty they lived for 2 weeks before they came to the university. I have argued elsewhere that as we look at our training models, that to me is a model we must think through, because as members of the university community, we are a privileged lot. Just by living in this university, we have power, whose monthly bills we don't even know. Neither the dean nor his student or his lecturers know how much monthly bills they have for this university. Somebody somewhere pays it. That's a privilege. Unless you go out there and live in the slum and see how somebody cannot afford a token of 5 shillings, you may not be very sensitive to this power. You may actually abuse it. But if you came back to the university with that sensitivity, you'll use water more responsibly, you'll use this power more responsibly, you'll appreciate the greenery here, you'll appreciate the food you get in your hostels, and you'll be generally a more responsible citizen who understands that the law that you study in law school and the law that you'll practice out there is law that is supposed to satisfy broader social aims. So what am I saying in closing? I am saying this as a university community that is generating the next generation legal practitioners, the next generation judges, the next generation attorney generals and state counsel in the office of the attorney general, as the next generation prosecutors in the office of the director of public prosecutions. I want to leave you with a saying that the price to pay for justice, the price to pay for good governance, the price to pay for an organized and well-ordered society is not law as rules, as an end in themselves. The price to pay for all these phenomena is actually a non-legal phenomena called eternal vigilance.